Got the list? KP Gopa Kumar. I am reading the operative portion of the judgment. The issue in the present writ petition has already been decided in the case of Ashish Mukherjee, WP 1747W of 2019. The decision of Ashish Mukherjee in the writ petition has reached its finality before Honorable Division Bench in MAT 193 of 2019. Though the university has preferred SLP review application as well as curative petition before the Honorable Supreme Court against the order of Division Bench, but the Honorable Apex Court did not entertain the university. So the decision of Honorable Division Bench passed in MAT 193 of 2019 is binding upon this court and it in its true perspective. It further appears that one coordinate bench in this court in WPA number 22027 of 2022 has decided the issue in favor of an accompanist with some unusual comments against the conduct of the university to proceed with these matters time and again before this court. It further appears that in the case of Ashish Mukherjee, by virtue of contempt application, a word of caution was passed by the Honorable Division Bench against the university, and the state took the responsibility to comply with the order passed by the Division Bench. It further appears that the coordinate bench of this court in WPA number 22027 of 2012 has issued some directive to be complied with by the university. Some of the directions were not complied with. Accordingly, by virtue of direction of a contempt application and in compliance thereof, the register of Rabindranath University was placed under suspension, and an office order of the Vice Chancellor of the University was issued on 15/1/2024, wherein the Executive Council has adopted the resolution on October 4, 2023, that the service of the accompanist teacher was extended up to their age of 65 years. The present petitioner is similarly situated accompanist teacher, and he is also entitled to get the relief as paid for. According to the instant writ petition disposed of with a direction that the memorandum of university dated 1st December 2021 issued by the registrar of Rabindranath University against the present petitioner is hereby quashed. The Rabindranath University directed to allow the writ petitioner to remain in service till 65 years of age by virtue of notification of State of West Bengal dated 27 January 2017 as well as 24 January 2019. The university is further directed to release the arrear salary and the current salary of the present petitioner by allotting regular duties. WPA 8498W 2022 connected CAN applications are disposed. Next.
Yes, Gujarat.
This is a review application.
Yes.
Review 185 of 2023 against the judgment dated 12/5/2023 passed by the appellate court. I am reading the only operative portion of the order.
Yes.
Having heard the learned advocates and after perusing the grounds mentioned in the review application, it appears to me that all the grounds in the review petition are were already raised before the appellate court. The appellate court has decided all the issues. There exists no new fact which discovered after the passing of the judgment under challenge. The points of review, that is the annual income of the deceased, rate of interest, and other pecuniary and non-pecuniary benefits, has already been argued before the learned appellate court. The learned appellate court also, after considering the materials, adopted the multiplier. After appraising the arguments of the parties, the learned appellate court has come to a conclusion that the award passed by the learned tribunal requires modification. Accordingly, the award was modified by virtue of provision under Order 47, Rule 1 CPC, as well as the uh, law laid down by the Honorable Supreme Court in Kamalesh Verma. I am of view that the instant review application filed by the present petitioner is not at all maintainable. The present petitioner wanted to repeat the old overrule argument which was already considered by the first appellate court. Thus, I find no justification to entertain the instant prayer of the present petition. Review application being meritless is hereby dismissed. Call the next matter. LCR. সব নিয়ে যেতে কোনো মধ্যে Yes.
Several grounds. One of the grounds is that the income of the remain deceased victim was taken, Lorna Campbell was taken at 28,600. But in claim petition, he stated the income of 20,000. And the contentions of the Lorna Campbell was that he was not a regular worker, he was a due to some statutory deduction, taken on 28,600. But Mala, I have studied the same as Mala. You also kindly see Mala the deposition of two. Deposition of two Mala, I have page Mala 23. Deposition of three Mala, deposition of three, page 23.
PW3.
PW3.
Page
23. And in cross objection, last portion Mala.
Yes. Who is this person? Sudeep Kumar Maiti.
The employer of the company.
Office staff of Messrs. Indian Construction as manager.
So he stated his income was 22,000. In his cross-examination, he stated that his last payment was 21,800, 500. Then I cannot say the monthly salary of the person 10 years back. Rupees 21,850 was the last monthly salary of the deceased. Once he stated the income of 22,000, again he stated the income last payment was 21,850.
Yes.
And you will also kindly see, next month you will also kindly see the register of wages. Estate mother. $69. Yes, $69.
Yes. What is the name?
Name is Madam Devkumar Maji.
Dev Kumar Maji.
6. Article number 6.
Yes.
But here the minimum rate of wages payable to each person employee is stated that Devkumar has Devkumar Maji 900 500.
9,500.
Madam, he is not cancelled. They are not overtime. He is not a regular worker, madam. What time is that your last circumstance and last payment was 21,825.
Yes.
And madam, deduction, that deduction has been made. Madam, there is no clarification for what purpose the deduction has been made. There may be income tax and others, madam. So, madam, he cannot claim his income was 23,000 or 20,500.
So what is the observation of the learned tribunal?
Learned tribunal observation of learned tribunal is that manner. The learned tribunal taken, he claimed 22,000. But observation of the learned tribunal was that the learned tribunal was taken 28,500, 600. Due to some statutory deduction. The observation of the learned tribunal.
So what is your submission?
My submission is that he cannot claim the rupees, his income was 20,600. There is not he is not a regular worker, and there is some deduction. And due to some overtime, he works not maybe between that. He cannot a regular worker and cannot every day he gets overtime.
Okay, tribunal took the monthly income of deceased to be 20,500 after some statutory reduction.
Yes, ma'am. But he is not a regular worker, but daily wages basis worker, so he cannot every day it is we can presume that every day he will not get any.
So how can we presume now that he work only 1 day or 30 days?
Only you also can say every income is four. We have four. The register of 4 pages has been annexed, that there is difference in every day, every year, in the month. Here the first page 69. Here 21,805. And next page 70 71. 71 the page his income was 21,600. And
Yes.
and page 72 his income was 22,100.
Yes.
And in page 73 his income was 21,850. So it differs only 5 copy of has been annexed.
So learned tribunal taken the lowest. Taken the lowest.
No, learned tribunal taken 20. He claimed 22,000. Learned tribunal taken 20,500.
Then the lowest. Learned tribunal has taken the lowest. What is your objection? Not the highest, but the lowest.
No, I mean that may be.
Okay, your submission is he is not the regular worker.
20,500.
Why?
Well, here he also consider minimum rate of wages payable to each person unemployed in 9,500.
9,500.
That doesn't mean the minimum wages, but it has been added for overtime.
Yes, overtime is provided, so they took the overtime. This is the nature of job. In every month, he took the overtime.
There may not be every day.
No. In every month, no. Where you were that there no. In every month, he took the overtime. There are some difference of overtime, but in every month, he took the overtime. But the learned tribunal has taken only less, 20,500. What are the reductions? Okay, I understand. After deduction, the amount has been taken in gross.
Another point is that
Very well. What is the another point?
FIR has been lodged after 4 months.
Yes.
On the explanation is that
FIR lodged after 4 months. Where is the FIR?
Page 29.
Okay. This is 156 subclause 3 application.
Lordship.
explanation is that the PS refused to accept the FIR. Then he filed under section 156(3) of the CRPC.
Yes. What is your submission?
There is this serious cost of doubt that it actually happened or not. The accident also happened on 13th March, and the policy was taken on 14th March, on the next day.
Next day?
On policy, the accident was happened on 24th, and policy was accident was happened on 23rd, and policy was taken on 14th March.
No. Accident happened on 13th. 13th of March 2021. And at that time, there are no policy.
That covered but that accident will happen on 24th, and policy was
No. Accident happened on 13th. Accident happened on 13th of March.
Policy was taken on 14th.
14th of March.
Next day,
on the next day.
Yes.
So on the 13th, there are no policy.
No, there is policy.
Then?
No, yes, doubt but the and FIR also was after 4 months.
No, that is the separate issue. You are asking about the policy. That is the otherwise. Policy was there, was covered on the date of accident.
13 হচ্ছে কোথায় পেলেন আপনি? 13 অ্যাক্সিডেন্ট করে কি বলছেন আপনি? জেনে বলেন। আপনি বলছেন কোনটা? আপনি যেটা বলছেন
Okay, accident happened on 14/3/2021 at about 7 a.m. Your policy is from 13/3/2021. Prior to that,
That
yes,
one day,
then
sir, one day,
so whether you have called for the UD case, which was UD case number 127 of 2021. That is the UD case registered due to such accident.
বলবো না?
Whether you call for the record before the tribunal, any evidence you have adduced?
no much.
You have not adduced any evidence. Yes, anything?
Another the accident happened between two motorcycles.
Yes.
Was on the person who was driving the alleged offending motorcycle, he has no driving, he has no authorization letter from the owner of the vehicle.
Who? The deceased?
Matlab,
The deceased?
authorization letter was taken from the registered owner of the motorcycle.
Who? The accused or the deceased?
Who is on the victim?
No, I cannot follow. Who don't have the authorization to drive the vehicle?
Owner of the registered vehicle, he has not given an authorization letter.
In respect of which vehicle? Offending vehicle?
Yes, sir.
Offending vehicle.
So insurance company is liable. That means owner of the vehicle.
Now, where from you are submitting such? Is there any evidence?
There is no.
There is no evidence. So, how are you submitting like that? Is there any police paper like that?
No.
What is the number of the offending vehicle? WB30N 58 9258. Yes, anything?
Another one, Mala, the clear consultation was granted, Mala, though there is no such position in pronunciation case, Mala. Only partial consultation. 88,000 had been given.
Refer me the page.
84.
84. I think so.
Future prospects added 25%.
That's correct, Mala. That's correct.
Multiplier adopted 14. General damages 70,000. Added 10%. Okay. Consortium for extra 2%, 88,000. That's all. Okay. That's all? Yes.
Rashid, the past issue, Mr. Roy raised the income. Rashid, I am also coming chronologically. Rashid, kindly come to the Rashid also already gone through the in wages sheet that is exhibited, and also the bank particulars that is also been exhibited. And Rashid, kindly see that the Dev Kumar Maji is basic, and then Rashid 6,600 what time 2,000 1,000, and Rashid they is earning that amount in every month. Sometimes ups and down, but every month is earning. But Lashib also knows that the parks and the overtime is also can be taken with the income. So the learned tribunal rightly observed that the income has to be considered as a computation for income has to be considered.
Yes.
And so the learned tribunal rightly decided that. And Lashib, I have also filed a cross objection on that issue that the learned tribunal Lashib ultimately actual wages paid. Actual wages paid Lashib will consider page 69 is the March 69. Then Lashib will found that the actual wages paid 2,416. Then Lashib kindly see deduction if any. So deduction 1,140 and 130 and 164. It may be proportional tax or income tax, but the amount of 1,140 that obviously the provident fund. That is the provident, but that the breakup is not there. That's true. But that amount is a provident fund amount. Because of 130 and 164, that cannot be a provident, but that can be a proportional tax or other any miscellaneous whatever. But that amount has to be considered. That part did not consider by the learned tribunal. So one the statutory document is there. One employer has come and deposed that he is my employee, he is the permanent employee, and his the wages sheet has been exhibited. But it cannot be said that he is not the income the overtime excluded. But it appears from that the provident fund of amount 1,140.
No, why from you are saying that it's the
Lordship, that
provided?
I mean I'm admitting that the breakup is not there.
Yes.
Breakup
Breakup
is
is not there.
Breakup is not there. But Lordship, even then, Lordship, kindly see the 130, 164, that amount has been deducted. So, under which headings the amount has been deducted? So, if the amount has been deducted, that is treated as the income of the deceased. This cannot be excluded from the income of the deceased. Even then, if I ignore 130 and 164, rupees 130 and rupees 164, then that it can be ignored. But 1,140, that has to become under provident fund, because he is a permanent employee. The wages document is there. In every pages lordship will found that same figure, 1,140. All the pages lordship want the same figure. Lordship will found deduction amount is same in every wages slip.
So whether 1,140 is the P-tax or 130 is the
Lordship, P-tax cannot be 1,000 every month. P-tax, professional tax cannot be 1,140.
IT,
Lordship,
income tax.
Lordship.
Income tax.
No, income in
As there is no such
breakup,
evidence, no such breakup.
No breakup.
So how can we presume that 1,140 is the PF
And
or 140 is the 130 is the PF?
in this regard, Lordship, I also did not cross-examine the witness who has come
Yes.
from the employer. That question I didn't put before the learned tribunal, so answer accordingly has not come.
That is not, no evidence is there.
Yes. So accordingly, the learned tribunal assess the amount of a 20,500. I can accept, because of I have no option to beyond that, because of I cannot.
You must have some evidence to that.
Yes, I can.
PF is the 130. PF is the 1,140.
1,040. That is my humble submission. Otherwise, Lordship, proportional tax and the other 164 maybe deduction or house rent, whatever. But I don't know. But Lordship, that figure will appear from the all papers, all wages sheet. And Lordship, I leave it to Lordship. And Lordship, kindly see the bank particulars papers also there.
What is the page?
Page 61. But that is not very clear to that extent.
What is this?
That is account name is Dev Kumar Majhi, general ledger. This is that extract from the office ledger. That is extract from the office ledger. Where from Lordship, the whatever figures is Lordship will found from the wages slip, the same figure will Lordship found from this the company's ledger statement.
This is not clear.
This is not clear. This is not clear.
I cannot read out it.
Yes, Lordship, this is not clear, and this also right. So the amount, the income as considered by the learned tribunal, I believe, more or less rightly considered. And second issue is that FIR, lodged FIR, and Lordship, the accident took place on 14th March.
14th March at 7 a.m.
Lordship, and Lordship, if Lordship will go through the FIR, the Lordship will found he has also mentioned. Lordship, kindly come to page 31.
Yes.
1, 2, 3, 4. Paragraph 4. অধীনের স্বামী পোস্টমর্টম তমলুক সদর হাসপাতাল হইয়াছে।
UD case number 127.
127. Then Lordship, kindly come to page 49. Lordship, I'm sorry, is going to teach. Has gone to teach. Lordship, kindly see left hand side postmortem report top.
Yes.
PS case number 127 or 127 21, and Lordship dated 14/3/2021. Same day PM has been done.
Yes.
Same day PM done. And one case also registered. And Lordship, then Lordship, kindly see name of the constable by whom the brought and name of the relative document. Constable C1225. Constable number.
Yes.
So constable brought the dead body to the hospital. So accident took place. Otherwise, the police will not come. It is not. There is no part of law of the relatives. The police has brought the dead body to the hospital. And Lordship, that question, they have raised the issue in the written statement, but they did not adduce any evidence. That is observation learned tribunal. The insurance company did not any evidence. The learned tribunal consider these aspects. The observation of the learned tribunal, Lordship, I am placing. Yes, Lordship, kindly come to page 79. This is the judgment. Fifth paragraph. On the other hand, learned advocate for the claimants have submitted that accident took place at the time of COVID restricted period and police was not entering the complaints during the said period. In this case too, that the police not first hand did refuse to take complaint and register it, which is why the claimant had to approach the court for registration of FIR. Though the order of the court, this is the order of the court also. In this regard, the tribunal had reflected upon the respective cases of the parties. The tribunal have also noticed that date and period that alleged the road traffic accident. It is also seen from the document marked Exhibit 1, 5 pages, that the complaint leading with the registration of FIR was fact that though the court of the learned magistrate and there is no impediment to the same, also considered the fact that the relevant period was COVID times. And at the said point in the Honorable Apex Court had issued the direction, thereby suspending the all periods of the limitation laid down in the law. The Honorable High Court have also issued the matching direction to be followed by the subordinate court and tribunals. Thus, in the context, any delay, there is a cause to be considered in the light of the relevant period. In this case, the delay cannot be taken as a consequential to the mentality of the instant proceedings. And then, Lordship, kindly come to page 80, last paragraph. On careful analysis of the said submission, one must understand that the learned advocate says no, so because there is a delay of lodging FIR, and within the said period, parties claiming an investigation of the alleged police complaint must have acted on the connivance of each party. That is the allegation of the insurance company. Thus, the allegation was not only against the claimants but also against the law of enforcement of agency. Without tinge any substance, one cannot raise doubt in the propriety of the law of enforcement agency who was investigate the complaint in the FIR. One must understand that the investigating agency would have submitted a final report as a false if the materials and substance procured during the investigation turns out to be a false. In this case, it is seen that even after filing of the charge sheet, there is nothing material to suggest that any objection have been raised, suggesting that the investigation was not proper. Even then, they did not raise the issue before the learned tribunal also. The charge sheet was not properly filed. Thus, one cannot doubt the propriety of the criminal investigation conducted on the basis of the written complaint, though it was filed after lapse of few days. The charge sheet of the criminal case was filed against the driver of the arrest of motorcycle. The said alleged motorcycle also seized along with the papers. And the eyewitness says, eyewitness not able to furnish the number of the motorcycle, but he said he is the Hero Honda Shine. Said Hero Honda. Ultimately, that Hero Honda motorcycle has been seized by the police. And then ultimately the land would come to observation, page 81. Therefore, let me know, reflect upon oral evidence as you in this case. Fact remains that one of the claimants, PW1, had filed the examination in chief on affidavit. He has stated about the fact of death of her husband in the motor accident as mentioned in the application. She has produced course of the documents of subordinate of the same, substantiate the same. The copies of the FIR, Caesar list, and the charge sheet and the police case also produced as marked and exhibits in this case. The copy of the autopsy report of the doctor and hospital was also produced, was marked as exhibit. That I have shown PM report for page 49. The copy of the valid insurance policy issued by the OP number 2 company was also produced. From the document marked exhibit to 3, it becomes clear that Kolhagat police have investigated the matter on basis of the written complaint filed by the claimant Mousumi Maji. Though the court and during the investigation, the offending vehicle motorcycle was seized along with the papers and driving license of the offending driver also seized. This fact are evident from the document marked as exhibit 1 to 4. It is seen that offending vehicle was one of the is one which was mentioned in the claim application. It's also seen that police investigation have also culminated into the filing of the charge sheet against the offending driver. Now, here the PW1 clearly mentioned that she did not see the accident taking place, but the claimant has adduced evidence of two eyewitnesses of this case, PW2 and PW4. Oral testimony of the two eyewitnesses as PW2 and PW4 cannot be doubted from the nature of oral evidence have been recorded, though there are not charge-sheeted witnesses. The PW2 in cross-examination clearly stated he has seen the accident taking place from the distance of 20 to 30 feet. He also stated that the offending vehicle has hit the victim from behind at the spot. He could not remember the registration number of the vehicle, but stated that it was the Hero Honda Shine vehicle. I will show that evidence. The seizure list also shows the vehicle motorcycle also fact of the Hero Honda. Moreover, another witness PW4 was very specific and clear, narrating the alleged accident. He did state before the court as to how the alleged accident took place. There is nothing in the cross-examination of the witness to disbelieve him, because the learned tribunal is witness of the trial. In this evidence, raised the matter in favor of the claimants with regard to the allegation rash and negligent driving of offending vehicle motorcycle mentioned in the claim application. On perusal of the place of occurrence of the alleged accident from this document and oral evidence, the tribunal is of the opinion that injury of the deceased was caused due to the alleged accident and also due to the rash and negligent driving of the alleged vehicle at the time of mention at the claim application. Thus, there is seldom in any doubt that can be raised herein. In this regard, fact accident took place, and accordingly, and I will come to a conclusion, he is entitled to get compensation. And Lordship, kindly, Lordship, once kindly come to page 31 in the FIR once again. Fourth paragraph that I have already read. অধীনের সামনে পোস্টমর্টম রিপোর্ট তমলুক হাসপাতাল হইয়াছে, যার তমলুক পিএস ইউডিকেস নাম্বার 127/2021 and dated 14/3/21 and PM number 23. Lordship will find 23 there and dated 24th March 2021. And then last paragraph. উক্ত ঘটনার কথা লিখিত আকারে আইসি কোলাঘাট পিএস এবং এসপি পূর্ব মেদিনীপুরকে ডাকযোগে মারফত ইংরেজি 20/4/21 ও 22/4/21 জানাইয়াছি. So, Lordship, his accident took place on 14th March 2021 and also informed the SP and IC of the concerned police station and Superintendent of Police just after 37 days. Reason is that he was busy for the rituals. That explanation is there. স্বামীকে চিকিৎসা এবং জন্য he was busy for that. For the reason he did not lodge the complaint. That explanation is given, and it was happened in the COVID period.
Yes.
And let's you kindly turn to page 26. The cross-examination of one of the eyewitness.
PW4.
PW4. Cross-examination after about 3-4 months from the date of accident, I have given similar statement to the police also. After the incident, I did not go to the police myself, but police authority have come to me for interrogation after 4 months. I have informed about the accident to the wife and victim, Moshimi Mach. I personally did not lodge any complaint. That's true. Not a fact, that false statement. So that has been tested. But they did not summon to the driver. They did not summon to the owner.
Yes.
And Lordship, kindly turn to page 22. There is the one of the another eyewitness. Kindly come to the cross examination. I am worker of the Ma Annapurna Dhaba, situated opposite the Suraksha nursing home. So first of all, it was admitted in the Suraksha nursing home. After that, he deteriorated the condition. Then he shifted to the hospital Puru Kamlu, where from the deceased died. Then I have seen the accident which took place one inch in front of the Kalimata Dhaba. In victim was coming from the side of the Kolaghat. The offending vehicle was also coming from the same direction, and and way, and on at 20 to 30 feet distance, the offending vehicle hit from the behind. Both of the vehicle fell down on the road. It's very natural. Both of the vehicle fell down on the, because both of the motorcycle. I was ill. I was ill at the time. At that time, I could not help the victim. Uh, uh, Victim were uh, taken by the machine van. I did not inform the Kolhagat police station PS. Police come to the spot and talked with me. And also kindly see, police come to the spot. That's why Lordship will find the constable number from the PM. For the reason the police has come, the constable number Lordship will find from the PM report. The constable brought the dead body to the Tomluk hospital.
Yes.
And talked with me. My signature was not taken. I do not know whether any GD or PS case initiated or not. I do not know often how many
After how many days?
How many days from the accident? The information was preferred before the court. I do not recollect the registration number of the offending vehicle. It was maybe a Hero Honda Shine. As you kindly see, he cannot say after 4 months. He cannot say recollect the number. He rightly said, but he said it's a Hero Honda Shine, and police also seized the Hero Honda. I did not inform the family of the
Victim.
Family of the did not inform family of the victim.
The family members of the
family
victim
of the victim reported
requested me to
depose. And I
work under the
work that and perhaps the Devbuto Jana such and such, thus I do not. So that has been clearly narrated the entire story. Two eyewitnesses there, the same thing they have stated. I'm placing this only cross examination, what the truth has come. Performed. And on that day, PM done. On that day, police has come. On that day, he has got to the hospital.
Okay, anything?
And Lordship, they did not put the question whether the employee, the deceased was the permanent or casual. But my humble sum is the permanent employee. Because of PF, everything is getting from their company. It is not that company employee will get that. The private job also getting that. The private job also a permanent job. But issue is the what time is the past. Lordships award the judgment of Lordship Indira Srivastava. The Lordship also the all the parks and everything is entitled to get entitled. So that cannot be reduced from the income of the deceased. This is what time. But even then, Lordship, my problem is that I not properly place that what the amount. So under such situation, I only relied upon the observation of the learned tribunal. Whatever learned tribunal decide, I will go.
So what is your argument regarding the future prospects? It has taken 25%.
Lordship, future prospect regarding 20% that I have answered before your Lordship, that the employer has come. Lordship, kindly come to the page 23.
No, if he is in permanent job, then it would be 30%.
Yes,
If he is a-
that is my submission, Lordship. He's the permanent job. That should be 30%. That's why pre-cross aggression. That should be 30%. Because Lordship, in cross-examination, they did not clarify the situation. Because under the impression, I know is is the permanent employee.
very well.
Actually, he is not a permanent salary or employee. Here, the register stated the minimum wages.
Obviously, they could
Actually,
disclose the
if
minimum
he is
wages.
permanent, that will be salary.
No,
Here,
that cannot be because of it is a private job. They should have disclosed the minimum wages because of they also can the minimum wages act. Unless they displayed or disclose the minimum wages, then they will difficult. They will the law will go against the employer. For the reason they were disclosed, what is the even that breakup is there. Basic pay, everything is there. Everything is there. And overtime, Lordship, Eastern Coalfield Limited, ECL, all the employees are getting overtime. All they are the permanent employee. It is not that if the permanent employee will get the overtime. Scope of.
That's all.
So, Lordship, kindly 30% future prospects instead of 25%. And the overtime cannot be deducted in view of the judgment of Indira Srivastava. Lordship, I am just placing the operative portion. Lordship, award that yes, the amount therefore which are required to be paid the deceased by the employer by way of parks should be included in the computation of the monthly income, as there would be been added to the monthly income by way of contribution to the family. Let's kindly see that the India's let's consider that. Kindly pardon me, I am folded the page. Just kindly look at the page 19, last paragraph.
Yes.
So the income as assessed by the learned tribunal should not be disturbed. Though I am not placing, cannot enhance that amount.
Very well. Okay, please check down. The instant appeal has been preferred against the judgment and award dated 13/7/2023, passed by the learned judge, Motor Action Claim Tribunal, first track, first court, Tamluk, Purvo Manipur, in MSC case number 490 of 2021. Stop. The claimants, stroke respondent number 1 and 2, preferred an application before the learned tribunal under section 166 of MA Act for getting compensation on the ground that their predecessor was died in a road traffic accident due to rash and negligent driving of the driver of the offending vehicle duly insured under the policy of the insurance company. Stop. Next para. The claim case was contested by the insurance company by filing written statement. Stop. Learned tribunal, after hearing the parties and after receiving evidences, has awarded a sum of rupees 29,91,000 in favor of the claimants and directed the insurance company to pay the compensation. Stop. Being agreed by and dissatisfied with the said award, the insurance company has preferred the instant appeal. Stop. Preferred the instant appeal. Stop. The claimants also preferred one cross appeal against the impugned award. Stop. Both the appeal and the cross appeal is taken up for uniformity of the judgment. Uniformity of the judgment. Full stop. Learned advocate Mr. Devnarayan Rai, appearing on behalf of the insurance company, submits that the impugned award passed by the learned tribunal is required to be set aside. Stop. He argued that the learned tribunal has assessed the monthly income of the deceased erroneously. Stop. The erroneously. The learned tribunal did not consider the evidences on record and assess the income of the deceased to be $20,500 per month. Stop. 500 per month. He argued that the deceased was not a permanent employee. He was only paid by the company on the basis of wages, on the basis of daily wages. So his monthly income cannot be calculated to be 20,500. Stop. Next plan. He further argued that the learned tribunal also failed to appreciate the fact that the FIR of the instant case was lodged after 4 months of the alleged accident. He argued that the alleged accident happened on 14th of March 2021, but the claimant, but the FIR was lodged on 5/7/2021. He submits that there are no explanation in such inordinate delay of lodging FIR. He argued that the the present offending vehicle must have implanted due to such delay in FIR. Due to such delay in lodging the FIR. Next part. Mr. Debrana Rai, learned advocate, further argued that the driver of the offending vehicle had no authority or proper driving license to drive the vehicle. He submits that the owner of the offending vehicle have never allowed the driver of the offending vehicle to drive the said motorcycle. In that score, the owner has violated the terms of the policy, so the insurance company is not liable to pay the compensation. Stop. Next, learned advocate Mr. Amit Ranjan Rai, appearing on behalf of the respondent number 1 and 2, stroke claimants, submits that the claimants have produced one employer before the learned tribunal as PW3. During his evidence, he has produced all the registers of wages, wherefrom it would be appear that the deceased Dev Kumar Majhi was a permanent employee and used to earn rupees more than 21,000. Stop. He further argued that the deductions and perks accepted by the deceased during his employment can be taken to be the monthly income of the deceased according to the observation of the Honorable Supreme Court in National Insurance Company Limited versus Indira Srivastava and others. Stop. He further argued that the the monthly deduction in the register appears that they are regularly deducted from the gross income of the deceased. Amongst them, the income deduction towards the provident fund need not to be deducted. Stop. Mr. Rai further argued that there are no delay in lodging the FIR. Stop. The accident happened during the COVID pandemic. Stop. After such accident, the widow was engaged during last rituals of her husband, and he lodged a written complaint to the concerned PS as well as to the SP Purva Medinipur just after completion of the ritual. But these applications were not taken care of, for which he preferred an application before the learned Chief Judicial Magistrate Purva Medinipur. Stop. Thereafter, by virtue of order of the learned CGM Purva Medinipur, the instant case was registered. Stop. He further argued that just after the accident, the dead body of the deceased was carried by a police constable and PM report was done. Stop. From the PM report, it would be revealed that from PM report, it would be revealed that one UD case being number 127 of 2021, dated 14/3/2021, was registered due to the death of the deceased. Stop. The number of the UD case is reflected in the PM report. On such submission, Mr. Rai submits that there is no doubt in such accident. He further pointed out the observation of the learned tribunal in the impugned award regarding the delay lodging of FI. Next, Mr. Roy further argued that the present deceased was a permanent employee, but the learned tribunal has committed errors by awarding only 25% of his established income towards the future prospects, as he was a permanent employee. According to the observation of the learned tribunal, according to the observation of the Honorable Apex Court, in National Insurance Company Limited versus Pranay Sethi, the future prospects would be 30% to the established income of the deceased. So he prayed for just and proper compensation. Next one. For the learned advocate, peruse the materials from record. In considering the first ground of appeal, regarding the income of the deceased, it appears that the learned tribunal has adopted the income of the deceased to be 20,500 per month. Stop. Learned tribunal has opined that the employer has appeared, manager of employer has appeared as PW3, and he produced the Exhibit 9 and Exhibit 10 series. Stop. It appears that the learned tribunal has adopted the gross actual wages paid to the deceased for the months. Stop. Though the gross wages payable to the deceased was 22,100, but more than 21,000. But after deduction, the learned tribunal thinks it fit that the monthly income would be 20,500. Stop. Mr. Roy submits that the 11,000, the deduction amount of rupees 11,140, 1,140 was deducted towards the provident fund account, but no such breakup or explanation was produced before the learned tribunal. Thus, I find no substance in the submission of the learned advocate for the Mr. Rai, learned advocate for the respondent. Considering the same, and also considering the observation of the learned tribunal, it appears to me that the learned tribunal has correctly assessed the monthly income of the deceased in this case. Stop. It further appears that the FIR was lodged after more than 3 months. After more than 3 months of the alleged accident. The materials goes to show that the widow of the victim lodged a petition of complaint under section 156 subclause 3 of CRPC before the learned tribunal. Thereafter, the case was registered by virtue of direction of the learned CGM concerned. Stop. The body of the application under section 156 subclause 3 contain the statement that the widow has approached the police authority before initiation of such application. I find no justification to entertain the finding of the learned tribunal in that score. Stop. The learned tribunal has correctly adopted the view that the accident happened during the pandemic period, and the evidence goes to show that the police has brought the dead body. So there are hardly any doubt. Brought the dead body to the hospital as well as the morgue. So there exists any hardly doubt regarding such accident. So I find I find justification in the observation of the learned tribunal. Stop. In considering the submissions of the learned advocate for the insurance company that the driver of the offending vehicle had no valid authority to drive the offending vehicle. Stop. It appears that the police has seized the offending vehicle, that is Hero Honda motorcycle, bearing registration number लिखो WB30N stroke 9258. Stop. The owner of the offending vehicle has appeared before the police authority and produced all documents. Stop. No evidence was produced by the insurance company to substantiate the plea of absence of any authorization letter from the owner. Considering the same, I find no justification to entertain the submission of the learned advocate appearing on behalf of the insurance company. Next paragraph. However, it appears that the Honorable Apex Court in Pranay Sethi has observed that the future prospects would be awarded in favor of the claimant under section 166 of MB Act, and where the deceased had a permanent job and age is between 40 to 50 years, the 40 to 50 years, the future prospects would be 30% of actual salary income of the deceased. But when the deceased was self-employed or in a fixed salary, the future prospects would be 25%. Stop. In this particular case, the PW3 appeared and submitted the registers. From the registers, it appears that the deceased was not self-employed or on a fixed salary, but it is true that he was in a permanent job. Considering the same, in my view, the observation of the learned tribunal, in my view, the observation of the learned tribunal regarding fixing the future prospects is erroneous. It should be full stop. It should be 30% to the established income of the deceased. Stop. However, the Honorable Supreme Court in Pranay Sethi Supra has only allowed the consortium towards the widow of the deceased, but in this case, the consortium was provided in favor of two claimants according to the law laid down by the Honorable Supreme Court in Pranay Sethi. That is not permissible. So in this case, the claimants are only entitled to get the claimants are only entitled to get rupees 44,000 towards the consortium. Next, under the above observation, the award passed by the learned tribunal requires modification. Monthly income 20,500. Next line. Yearly income 2,46,000. 46,000. 30% is added towards the future prospects. That is, so after adding the future prospects, the yearly income comes to rupees 2,46,000 plus 73,800. 2,46,000 plus কত বললাম 73,000 এটা তুলে দেবেন 9:30 এটা তুলে দেবেন না বুঝতে পারলে আমি বলে দিচ্ছি এটা হচ্ছে মান্থলি ইনকাম yearly income 1/3 deduction towards personal expenses towards personal expenses ঠিক আছে তাহলে এটা মাইনাস এটা হচ্ছে 30% ফিউচার প্রসপেক্টস অ্যাড হচ্ছে এটা এটা হলো এটা হচ্ছে জেনারেল ড্যামেজেস হট 70 এটা বলা না ওটা কেটে দিন যেটা বললাম ক্যালকুলেশনটা করছিলাম হ্যাঁ 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 So after calculation, the award comes to rupees 20. What is the award? 29 lakh.
29 lakh in 91,000. Page 84.
No, what appears after calculation?
29,200. No, 20 lakhs to 20,000. Sorry. I mistake.
Your calculation, what is this? So where is the multiplier? You have not multiplied.
Sorry. Because I'm supplying funds.
Multiplier is 14.
14. I'm supplying lossy further.
You just check it.
So put it 40% into 14. 200. Yes, loss. Yes, 2094. Yes, loss. 361,800. 361,800. So London Terminal allowed at 29,90, 91.
No, you have deposited the entire awarded sum. Okay. Okay. So after calculation, the award comes to rupees 30,61,800. Dots. Stop. The 30,61,800. The learned tribunal has already awarded a sum of rupees 29,91,000. So the balance award comes to rupees 70,800. 70,800. The insurance company is directed to pay the balance awarded sum along with 6% interest per annum from the date of filing of the claim application through the office of the Learned Registrar General High Court, Calcutta, within 6 weeks. Stop. Next para. The office of the Learned Registrar General, it appears that the office of the it appears that the insurance company has already deposited the entire awarded sum. Stop. The said sum must have carried some interest. Stop. Interest. Stop. The office of the Learned Registrar General High Court, Calcutta, is directed to disburse the amount in favor of the claimants within 4 weeks. Within 4 weeks, along with the accrued interest, according to the usual norms. Stop. The after deposit being made by the insurance company in respect of the balance award along with the interest, the claimant respondents are also entitled to get the same according to the general norms. Stop. Stop. You have to pay the extra
Deficit
court
is
fees.
subject to payment of court.
Yes, the payment of compensation is subject to ascertainment of payment of deficit court fee if any. Stop. Next para. The office of the Learned Tribunal shall act upon the certified copy of this order to receive the deficit court fee if any. The deficit court fee if any. Stop. The FMA 966/2023 along with court number dash unconnected can applications are disposed of.
Lordship filed on Lordship 26 August 2021, date of filing.
The balance insurance company directed to pay the balance from the date of filing of the claim application. What is the date?
26 August 2021.
Is it 20,000, 70,800 holo? Back at 26
August 2021.
26/8/21 ওইটা করো। আচ্ছা এটা একটু বুঝে নিন। মান্থলি ইনকাম, ইয়ারলি ইনকাম, 1/3 ডিডাকশন টুয়ার্ডস পার্সোনাল এক্সপেন্সেস, এইটা মাইনাস হলো, এটা এলো, অ্যাড 30% ফিউচার প্রসেস অ্যাড হলো। এবার এটা হলো মাল্টিপ্লায়ার ইন্টু 14 করে এই অ্যামাউন্ট হলো, ঠিক আছে। তারপরে এটা হচ্ছে জেনারেল এক্সপেন্সেস অ্যাড হয়ে এইখানে অ্যাড করে দিচ্ছি, এইটা হলো টোটাল। তারপরে বলে দিচ্ছি। হুম 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 হুম
Item number 6, my lord. I was waiting on that. Item 6 my lord. Monday I have to person. Item number 6. 6.
Item number 6.
My lord.
27
Right.
under the same heading. Okay, 27. Yes, all other answers. In second half, I have also note. Okay. হুম। দুটো উঠবো, আমার 3টে অন্য কোড আছে, যতটা হলো হলো তার বেশি।
এটা তো তোমাদের দিক থেকে
Yes.
Please, Your Lordship.
Other matters are released.
Other matters are released.
So serial number 8 was today fixed. So it may be taken on Monday.
Regularly it will take on Monday.
May it please, Your Lordship. I'm appearing for the petitioner.
Yes.
Kindly permit me to start because
Yes.
I'm being led by Mr. Shoptangshu Bose. He's on his way. He'll be here. Lord, before I take Your Lordship to the facts and I try and encapsulate the facts as to why the petition is necessitated in the present proceeding, may I request Your Lordship to take up page 16, paragraph 13 of the petition. On the last day when the matter was taken up, it was indicated by my learned friends that they would take a point of limitation.
Yes. So you are moving an application for recalling.
Moving an application for recalling.
Yes. This is can 1.
This can one.
Yes.
Because in our very respectful submission, the service was not proper. It was moved, it was indicated before Your Lordship that it has been served, but the service was not proper. I'll indicate that from documents, but before that, may I only read out paragraph 13, where we state that the applicant came to know about the said order. This is the order, my lord, of which we are praying for recall. November 1, 2023. On 20th November 2023, when the petitioner filed a copy of the said order before the recovery officer, Debt Recovery Tribunal 1. This is Bombay DRT, my lord. And the applicant immediately conducted an inquiry and found out that the said application has been served in the Chennai office of the applicant instead of the
You are
Bombay
reading
office.
page number.
But I'm reading page number 16 of the petition, my lord.
Of the petition. Yes.
My lord.
Yes.
Lord, the applicant, this is, my lord, the date of knowledge. It is only for that that I'm referring to this paragraph. It has
Page
been
number
explicitly 16, my lord, of the petition before Your Lordship, the recalling application.
Can 1.
Can one, my lord.
Page number 16 is in the National Company Law Tribunal. Company petition number such and
My
such.
lord, 1/6, my lord. Lord, may I try and assist Your Lordship?
Yes, this is the your.
Huh? I believe my lord is looking at the opposition. This is the affidavit in opposition, my lord.
Oppositions. Okay, got it. Page 16.
Page 16, my lord.
Yes, got it.
I'm only referring to this, my lord, for the date of knowledge and the filing.
Yes, proceed.
The applicant came to learn about the said order dated November 1, 2023 on November 20, 2023, when the petitioner filed a copy of the order before the recovery officer, Debt Recovery Tribunal. This is the Bombay DRT. And the applicant immediately conducted an inquiry and found out that the said application had been served in the Chennai office of the applicant instead of the Mumbai office. Copy of the said order dated November 23 and copy of the sanction letter of October 6, 2017 are annexed. But kindly note, this application, as it would appear from page 19, was affirmed and filed on 20th of December. So it is exactly 30 days. This point of limitation in my very respectful submission cannot be taken. Now, my lord, the order may I first refer to is at page 168. Page 168.
Yes.
But I'm only trying to assist your lordship by reading out this order first, because otherwise, my lord, if my learned senior starts thereafter, so that he can start the topic, my lord, otherwise I'll then enter into the main facts. This is the order of which we are seeking recalling. Affidavit of service filed by the petitioners and court taken on record. It appears from the affidavit of service that the petitioner, in pursuance of the order of this court, has served upon the opposite party numbers 10 and 11 in respect of the petition along with the connected papers. That we are opposite party number 10. None appears on behalf of respondent number 10. Heard the learned advocate for the petitioners at length. The instant civil revisional application has been preferred against the order dated 18th October 2023, passed by the learned additional district and sessions judge, fast track 4th court, Parasat, in Ms. K. So-and-so. Additional district and sessions judge has refused to pass an interim order of injunction in favor of the petitioners. Hence, the instant civil revisional application is preferred. The brief facts of the case is the present petitioners are the recorded owners of a plot. This is their case, my lord, which they sought to make out, of a plot comprising of an area of this, lying and comprising at this Gopalpur municipality under district so-and-so. The agreement was entered into, the next paragraph, the agreement was entered into between the present petitioners along with the opposite parties on February 5th, 2005 for using such land for preparation of the building comprising of 6 floors. It has been specifically agreed between the parties that the present petitioners would have only right over ground floor and top floor of the building. On the basis of such agreement, the building was constructed. It's come to the knowledge of the present petitioner that the office of the DRT Bombay has initiated a proceeding in respect of the other owners of the property. It is the fact that the DAG numbers in question before the learned DRT is also comprising of the said building along with DAG number 1 owned by the present petitioner. Finding no other alternative, the present petitioners have preferred a suit before the jurisdictional court and have prayed for order of injunction. The said order of injunction was refused against which miscellaneous appeal was preferred before the first appellate court. Perused the order passed by the learned first appellate court, it appears that the learned first appellate court, after carefully perusing the prayer of the injunction application, came to the opinion that the plaintiffs, that is the petitioners herein, has prayed for injunction in respect of the entire building over which he does not have exclusive right. Learned advocate for the petitioners referred the prayer made in the plaint itself, wherein the declaration was only sought for in respect of ground floor and top floor. It is admitted the learned advocate for the petitioners. This is the case that they are seeking to run.
Yes.
And this case is not correct. Kindly see, your lordship has accepted their version, and thereafter your lordship has passed an order. This is the internal page 4 of the order, the last paragraph, the last
Yes.
4 lines. Considering the same, the opposite party number 10 is hereby restrained to issue in any sale certificate in respect of the ground and top floors of the building situated in this. And this is the finding rendered by your lordship, which we are aggrieved with, and my lord, hence the present application. My lord, the conspectus of the facts, if I may refer to, before I take your lordship to the first order of the trial court, the appellate court's order, and the DRT order. This, in essence, is an order passed by the DRT Bombay. That order is subsisting. That order is not challenged. Today, they are seeking through this proceeding, circuitously, because they can't do it otherwise, to take out the sting from the order of the DRT Bombay without challenging that order. That order stays at them. And in my very respectful submission, this honorable court does not have jurisdiction even in a 227 over DRT Bombay Tribunal. That has not been pointed out by my learned friends to your lordship in the course of this proceeding. What is the proceeding? What is the dispute about? So the dispute is this. The landowners enter into an agreement with the developer. The developer for the project, and it is the usual development agreement, where the agreement is that after development of the project, they'll have a ratio to themselves. A few flats will be taken by the owners. The rest, the developer has the option of selling and making profit out of those sales. The commercial arrangement. In lieu of this arrangement, for development of the project, they take loan. They here means the developer. Developer takes loan. In consequence to the original agreement, the arrangement is that if as and when the property is developed, a few portions of the property, the flats, would be made over to the owners. That's the arrangement. Today, the developer takes a loan from a financial institution. The developer fails to repay the loan. The developer is proceeded against by the financial institution before the DRT by invoking appropriate provisions of the law. DRT comes to a finding. They now want to proceed against the developer because it has rendered a finding against the developer. Very conveniently, the owners then come and say that in this factual situation, my rights have to be protected because in the agreement, I had a portion which is to be secured that could not have been mortgaged. If that is the case, then in every matter, there will be an impediment and the process will come to a grinding halt, which cannot be the law. It cannot be the purport of the law. May I show the reasoning? Because what have they done after this? Essentially, when the order stares at them, it is like challenging an execution without challenging the decree. That's effectively what is being done. They file a civil suit before the trial court. Your lordship will find the order of the learned trial court at page 102. There are two numberings, my lord. One is faint, 131, and the right hand numbering, which is bold, is the one that I would request your lordship to follow. Page 102 of the petition. Because they have lost before the trial court, they could not get an order in the ad interim stage. They lost before the appellate court also. Yes. We're at page 102. The record is taken up for passing the ad interim order of injunction under Order 39, Rules 1 and 2, CPC, filed on behalf of the plaintiffs. I'm skipping the first part. The fifth line, my lord. This is a suit for declaration and permanent injunction. The suit property is described in the schedule of the plaint and in the application for injunction. It is the plaintiff's case that the suit property described under Schedule A belongs to the plaintiffs, which they have jointly purchased by a deed of conveyance dated 2008. Further, the plaintiff's case that the defendant numbers 2 to 7 had purchased different properties abutting the land of the plaintiffs through 6 deed of conveyance. Thereafter, the defendants entered into a development agreement with the plaintiffs for the purpose of developing their own land, including the floor area ratio of the plaintiff's land to which the plaintiffs consented. The defendants constructed only the superstructure of the basement plus ground plus 6-storied structure. As per the development, the plaintiffs were supposed to be allotted the entire ground floor and top floor of the building to be constructed. It is alleged that the plaintiffs that the defendants had mortgaged the said building as a collateral to secure loan. The defendants here, my lord, is the developer. However, the plaintiffs had no knowledge of such mortgage. Very convenient, my lord. They did not have any knowledge. A sale notice has been published by the defendant number 10, that is, my lord, the petitioner before your lordship in this proceeding, and 11 with respect to the scheduled property. According to the plaintiffs, such action of the defendant number 10 and 11 invades the legal right of the plaintiffs in the suit property, which have accrued in respect of the ground floor and the top floor of the building. Thus, the plaintiffs have prayed for an order of temporary injunction along with ad interim order to restrain the defendant numbers 10 and 11. These are the financial institutions, my lord, from proceeding with or acting in terms or in pursuance of the sale notice dated September 8, 2023. It is well established principle that while considering the application for injunction, the court is to look into the following conditions. It includes prima facie case, a need to protect the plaintiff's right weighed against the need for protection of the defendant's right, and a clear possibility of irreparable loss and damage being caused to the plaintiff if the injunction is not allowed. Over the page, my lord. This is a suit for declaration permanent injunction. In order to establish their case, plaintiffs have filed copies of documents. Prima facie case contemplates bona fide dispute which is required to be determined without prejudging the case. It is also required to establish that court's interference is necessary to protect the plaintiffs from injury as contemplated in the application. Now, on perusing the injunction application, along with the documents filed by the plaintiffs, it appears that defendant number 10 is the certificate holder. That's the petitioner before your lordship, my clients. And Debt Recovery Tribunal is proceeding under Recovery of Debts Due to Bank and Financial Institution Act 1961. The defendant number 10 under DRT is proceeding for recovery of loan for realization of 30 crores together with interest along with cost and expenses as per the recovery certificate or decree. But this is the recovery certificate or decree which has not been challenged, Miller. It has been well laid down that grant of temporary injunction is not ordinarily permissible against state financial corporation from recovering loan and from management and possession of property mortgaged. Furthermore, it is required to be pointed out that injunction cannot be granted when equally efficacious relief can certainly be obtained by the usual mode of proceeding as laid down under the Specific Relief Act. And this is the reasoning given at the ad interim stage why this prayer has been refused. Now, the order in appeal, my lord, your lordship will find at page 135. Page 135, my lord, is the order in appeal. I'll only refer to because here also, my lord, the appellate court has refused the ad interim injunction. Page 136, it starts from 135, my lord. 136, the first paragraph is all that I'll rely on.
Yes.
On careful perusal of petition of plaintiffs or appellants as well as documents relied on by them, it transpires that Office of the Recovery Officer, Debt Recovery Tribunal, Mumbai, issued proclamation of sale under the provisions of law. In the instant application, plaintiffs or appellants have not sought for protection of their admitted property but have come before this court by filing instant injunction application for setting aside the impugned order passed by the London trial court, restraining the proceedings with sale notice issued by the competent authority and also restraining defendant numbers 10 and 11 from issuing certificate in the event of execution of auction sale. I'm of the view that the respondent numbers 10 and 11 are required to be heard before passing any order against them, or else it will cause miscarriage of justice to them being institutional authorities. This court is of further view that there is no bona fide reason and urgency in the matter for passing ex parte order against these respondents as prayed for by the plaintiffs' appellants. This being the position, I am not inclined to pass. So that it is affirmed. These are very important, my lord, because this is where the case has been considered twice and rejected.
Yes.
Now, my lord, may I have your lordships? May I pray for your lordships? Kind leave
Yes.
to allow my learned senior to take over, my lord.
Yes.
And it's only from the divisional application that we come to know of the state of proceedings for the first time. plaint injunction applications, not orders of the first court and the first appellate court, all annexed to the civil revisional application. And only from this copy we come to know for the first time that so many proceedings have taken place against me, all behind my back thus far. And it is for recovery of 30 crores and not public money.
No, whether no notice was served in the proceedings upon you?
No, all ex parte identity order refused.
One so-called notice was issued upon you by the appellate court.
That was directed to be issued.
Okay.
Now, please have a look at page 152, and the prayers in the plaint, which might have persuaded your lordship to pass this restraint order. Please have a look at the plaint first, that whether it is the game of the plaintiff to obtain something in a roundabout manner, which they had failed to achieve before the tribunal. And all jurisdiction is in Mumbai. In 2017, a sanction for loan is granted. Now, my learned friends try and come up with a story that in 2005, I had entered into a development agreement, which I had registered in 2022. But I have a further leader.
Now I came to learn he is assisting me.
None.
May I take over?
Yes.
I will try to make it very short.
Yes.
But application is under order 9230. Nomenclature is not necessary in 930. Why? My first point is that in the suit, the subject matter of challenge is a notice of self emanating from Mumbai.
Dear to Mumbai.
No, self. But kindly come to the plate. Kindly come to page 20. Page starts at 20. Kindly come to page 31 is the prayer B.
No, you are referring page.
Page 20 is the plaint.
Right.
It starts of my application for, in my lord's language, is order 9230. Here it is nomenclature is recalling of the order. B, prayer B at page 31. Has my lord got it? উঠুন তো দেখুন তো কোন অ্যাপ্লিকেশনটা দেখছেন মাইলর মোটাটা দেখুন
Page 31.
page 31. Kindly come to prayer B.
Yes.
A further decree of declaration that the auction notice dated 8 September 2023 being annexure D, E thereof are bad in law and not binding upon the plaintiff and are liable to be set aside. So this is the prayer in the plaint. Naturally, my lord, your lordship will be keen to look who is issuing this notice of sale, because this is subject matter of suit challenging this to be null and void. Kindly come to page 84. Kindly come to 84 at page 84A. I will not trouble also the entirety. Kindly see the top.
Yes.
But kindly see at the top, Office of the Recovery Officer, Debt Recovery Tribunal, Mumbai. And this is my lord. Sell notice. Sell notice. Sell notice. 86, 87. This is issued from, I want to show to you where from it was issued. But kindly 84B. Recovery Officer, Mumbai.
Yes.
So my lord has actual experience in the lower judiciary when we challenge an order issued by a particular authority. That particular authority has to make party in the. Now kindly see who are the defendant in the suit. While challenging the order of District Court Tribunal Mumbai, kindly come to page 20. Yes, kindly come to 22, defendant number 10.
HD. Okay.
10. IDFC First Bank
IDFC.
Limited, an existing company within the meaning of the Companies Act and having a registered office at Chennai. Knowing fully well that they are going to get an order for setting aside a sale notice issued by Mumbai. But how, my lord, the court can expect that if the notice is served to Chennai, who has nothing to do with this matter, is dealt with by a separate branch, and the Tribunal of Mumbai is of the matter, they have not been made parties. The bench has not been made parties, and my lord is rightly said that after service of notice, none appeared. First of all, I want to justify the conduct of my client whether there is sufficient ground for non-appearance. My lord has pointed out that none appeared.
Yes.
If the Mumbai party who is dealing is not been made parties, and I kindly allow me to use the word intentionally to misguide the court. But this is my first ground.
Yes.
I am taking aid from my lord order 9 rule 13 that if I can satisfy my lord that there are sufficient ground for non-appearance, the order will be recalled. So this is my first ground. So it will, according to my humble submission, on this ground only, the order of passed by my lord requires to be recalled by my lord.
Yes.
But my lord, intentionally it has not been made part. Now, my lord, second point. Yes, my lord, my lord, kindly come to another document. 182 it starts. This is, my lord, the sanction letter of the secured loan issued by at kindly come to 187. And another thing I will point out before your lordship.
Page 187.
Page 187, kindly come to the ouster clause. That was also not placed before my parties irrevocably agree that only the ouster clause, only the Court of Competent Jurisdiction Mumbai, India shall have exclusive jurisdiction in relation to any dispute or difference between the parties, including any question as to whether or not any dispute or difference shall herein arisen. The term sheet shall be governed by the law of India.
Yes.
So it is all known to them. It is all known to them. Another, my lord, order sheet I want to show to your lordship. That's it. Sanction letter 182, 174. Number kindly come to one order at page 174. But is looking something at displaying letter. But kindly come to 1674.
Yes.
This is recovery certificate. So decree has been passed. Can you see who is the applicant in the proceeding? IHBFC First Bank such and such, Bandra East, Mumbai. As one colleague pointed out. Now another interesting thing, Kalika. This is the proceeding was continuing when my learned friend's client appeared before the board, Trade Recovery Tribunal, Mumbai. Kindly come to 178. Last paragraph. At this stage, after passing the above ordered, learned advocate Mr. Nishant Rana appeared on behalf of the third party who? Joy Badrinath Niketan Private Limited and Joy Rajovi Enclave Private Limited. And place the such. I have not done that. So it is known to them. They entered appearance there in the Trade Recovery Tribunal proceedings at Mumbai. In spite of, it presupposes he is of the knowledge of everything, starting from certificate, everything they have the knowledge.
No, these are pertains to the merit of this entire civil matter or everything.
No,
So
I want to show to you, Lordship, that why we could not appear before mine.
Okay.
And why the Calcutta High Court was chosen. Or the in West Bengal it has been chosen. So everything is known to them. Exclusion of jurisdiction, they appeared in the proceeding, everything. Mumbai head office, Mumbai office is the has sanctioned the loan, everything known to them. Am I clear to mind?
Yes.
So that part I am concluding in a one go, not piecemeal. So this suggests that your lordship's order is required to be recalled on the ground that my lord has not been given the proper guidance that the Mumbai office is not a party and it has served in Chennai, so it has not been received by Mumbai. When it was received, now we are came to learn that this order has been passed by my lord. Now you have to put my. Now the main crucial thing is the it is suit maintainable. Now I kindly come to the plane. 1 second. What they are challenging? They are challenging the sale notice issued by Trade Recovery Tribunal, Mumbai.
Yes.
Now kindly take trouble to see the act. Section 80. On and from the appointed date, no court or other authority shall have or be entitled to exercise any jurisdiction, power or authority except the Supreme Court or High Court exercising power under 226 to 27 in relation to the matter specified in section 17. Provided that any proceeding in relation to the recovery of debts due to any multi-state company, there is not necessary for. Now kindly come to 17. And my lord has to consider whether the dispute sought to be raised in the suit is covered under section 17. A tribunal shall exercise on and from the appointed day the jurisdiction, power and authority to entertain and decide applications from the banks and financial institutions for recovery of debt due to such bank and financial institutions. Without prejudice to subsection 1, the tribunal shall exercise on and from the date of the appointed by the central government the jurisdiction, power or authority to entertain the decide application under part 3 of insolvency not necessary. The tribunal shall have circuit sittings in such and such. The appellate tribunal decide. So all disputes touching the affairs of the banking loan, meaning by is touching the loan has to be by Trade Recovery Tribunal constituted under this act. And section 18 is a specific bar.
Yes.
If there is any doubt, my lord, kindly
I understand.
ask. So this has been suppressed before my. This has not been suppressed means I am saying in that matter, my lord, everything we read right in the petition. But it is not possible for the court to go to every page and find out what is there. What we argue that my lord hears and give judgment. So if this the point which in the suit they have prayed for a decree is the sale notice. So it is covered under section 17 and is barred under section 18. What is this? But kindly take trouble to read 3 paragraphs 7, 8, and 9. Industrial Investment Bank. 17.
Yes.
They are at an interim stage. In this judgment, the fact was at an interim stage, court interfered, Supreme Court says no, we should not. But here, when a decree passed, or initially when these matters was I started dealing with, they used to say these says they are habituated there, certificate. Then I came to understand that certificate is a decree in our language. So in this case, decree has been passed. This is at the execution stage of the decree. Sale means execution of decree. If at the initial stage court cannot interfere in a dispute touching the affairs of the bank loan, which to be exclusively dealt with by the Directive Court Tribunal, whether after the decree, a court, a civil court can interfere. This is has to my lord to consider. This is my lord, my first submission. Second is that my lord has seen the trial court and appeal court both concurrently negative.
Yes.
Well, although my lord, it is not an appeal, but I don't ever think, my lord, I am criticizing your lordship's order here. I am only submitting, my lord, this is the reason for which we cannot appear. Now, if I am satisfied that my lord is reopening the matter, on reopening, I am making my submission. I am now citing a judgment where Supreme Court says if both the court concurrently negated their order,
Yes.
then High Court will be very slow in altering that. That is reported in. Let me show to lordship first how the trial court decided that, and the appellate court decided. Have you got order to? Well, kindly come to page 135.
Yes, it was referred.
135?
It was referred, already referred by them.
Why? Oh, let's go.
Yes.
So I want to show, I will not travel. I want to show to you from the both the orders, trial courts and appeal court, both the orders concurrently negated the injunction.
Yes.
Now what should be the, in that context, what is the duty of the High Court? I am relying on 2010 two Supreme Court cases. (142). But kindly come to paragraph 19. (19, 20 and 21). The reasoning given for reaching to the conclusion at paragraph 22. So I will place 3 or I will straight away come to the conclusion of the Supreme Court.
Paragraph 22.
Yes. The ratio of the aforesaid judgments is that once the court of first instance exercises discretion to grant or refuse to grant relief to temporary injunction, and the said exercise of discretion is based upon objective consideration of the material placed before the court and is supported by the cogent reason, the appellate court will be loath to interfere simply because on a de novo consideration of the matter, it is possible for the appellate court to form a different opinion on the issue of prima facie case, balance of convenience, irreparable loss and injury. Here, my lord, Supreme Court is saying if the trial court exercise, appeal court will not. Here, both the court concurrently held. I will not suggest, my lord, section 100 because it's not a second appeal, but I am finding the civil procedure court is giving a guideline to the court.
Yes.
If in a given case the court in the second appeal is restrained from giving a third opinion, reappraisal of evidence under section 100, then why that ratio will not be applicable? Both the courts will have concurrently held, no, injunction should not be granted. Then your lordship was not placed those, that's why your lordship was pleased to, but I repeat, I am arguing today as if when your lordship's order is not there.
Yes.
Before that order,
I understand. No issue.
My lord, I am arguing. Keep your lordship's mind.
Yes, yes.
So this is, my lord, the judgment which Supreme Court says that concurrent finding or even a finding by the trial court, because these are discretionary relief. If the discretion exercise judiciary with the materials available to the court, the fact-finding court, the apart forum will be very slow, very, very slow. In exceptional cases, it can. According to me, my lord, this is not an exceptional case. Coupled with the fact the suit is barred. Now, my lord, another judgment I will only cite for your lordship consideration, that is that before passing an injunction order, court must be satisfied the court has jurisdiction to pass this.
Yes.
That is, my lord, reported in 2004 1 Calcutta High Court Notes 498. 2004 1 Calcutta High Court Notes 498.
Time horizon. You need some time, more time?
No, I've concluded. Oh, 2 minutes late. That's all.
Okay.
Already, my lord has to see my paragraph 18.
Paragraph 18.
18. Just this. No, this side.
Okay, very good.
Because according to me, the prayer made in the plaint clearly demonstrates that it is a dispute in the banking loan. And the tribunal has passed an order for sale. That's all, my lord. In context, I submit, my lord, the order passed by your lordship first to be recalled, and thereafter, my lord, division has to be dismissed on the ground that suit is not maintainable, so the injunction cannot be granted.
Okay. So when you
Any
can
date your lordship keeps it, my lord?
tomorrow? Tomorrow means Monday.
Yes. Monday, my lord, if it has some difficulty, but Tuesday, if it can. My lord is very accommodating. No problem about it.
Tuesday 2 p.m.
Yes, Tuesday, I'm in some difficulty.
Then you both come.
Decide.
You both
With
decide.
my experience of 30 years, whenever a court suggests a date, we must have a difference. Always.
My lord,
Now-
kindly then keep it on, my lord, next Friday, then, my lord. We have Friday today, 23rd. I'll also get some time to get ready. Friday, no.
We have Wednesday.
Now, Wednesday, second half, I have some other matters. And Thursday, second half, also some criminal matters. This is the
Second half,
cases we are taking.
Both your how my lord is tackling.
Monday करा दो यार, हम नहीं करेंगे next week.
I have seen just
Now, Wednesday, I have second half, I have your read matters.
that is good.
Yes.
Not criminal.
Friday, I'm not in town.
In Thursday, some criminal matters.
That I don't like.
No,
Criminal matters.
My lord keeps it on Monday. He'll come on.
Monday.
Monday means this
Hey,
Monday.
Tomba.
Monday 2 p.m.
2 p.m.
Very good. Please take down
Rest of the week.
argument on behalf of the defendant, opposite party number 10. Concludes. Let the matter fixed on Monday. That is on 26
26.
at 2 p.m. as a special fixed. Okay. Yes.
Mic lage na.
Okay. You will go on that.
May I beg a pardon, but I could not appear when the matter has taken up for the deliberate judgment. All matter was not taken up by the court number 35. So
Okay, no issue.
my lord has deeply developed the much time in the matter. So I think my lord has disposed of it.
Yes. The petitioner has get the relief.
My lord, now in that contempt proceeding, everything has been completed.
Yes, everything has been completed.
Money is to be released.
Okay. I have passed the order, money and the all area to be released.
The requisition already sent before the government by the College of University Authority. Now it is probably they are going to. release.
Okay.
My lord has created problem for me in what matter?
Your matter.
Yes, my lord has created problem for me
Why?
because I have to re-argue, refer to larger bench.
No, I have already cleared it.
Don't, my lord is new here. Don't always take seriously my statements.
I understand.
Not all statements.
Okay.
তুই তো আগে জেনেছিলাম তো এখন জানতাম আমি ভাবছি আমি গেস করলাম কি আমরা সাইড করছে
Original side.
Original side, listed matters, specially assigned matters. Item number 1. Full appliances and equipment private limited versus official regulator.
কি আছে এটা কেউ নেই হুম অফিসিয়াল করে ডাকতে হবে তাহলে ডাইরেকশন দিতে হবে তো কাকে দিতে হবে রেজিস্টার জানেন হবে কি হুম item number 1 none appears on behalf of the petitioner. The official liquidator is also not represented. Accordingly, learned way is directed. Learned way is directed to represent one advocate, to appoint one advocate in this matter. তাহলে তাই করতে directed to appear personally or to an advocate in this matter on the returnable date. Let the matter appear in the list next Friday. Same time at 2 p.m. Next,
Item number 2. Order of Jupiter PLC.
দেখিয়েছে who is the advocate on record? Sunita Agarwal, advocate record on behalf of the petitioner. None appear on behalf of the petitioner. Accordingly, the advocate on record, Sunita Agarwal, Miss Sunita Agarwal, required to be informed regarding the proceeding of this matter before this court. The office is directed to inform Ms. Sunita Agarwal regarding the returnable date. Let the matter appear in the list on next Friday at 2 p.m. Same order.
Item number 3. Order of Jupiter.
Same order. ঠিক আছে হ্যাঁ কি আছে কি আছে বল দিন কি আছে
Again, I am here to disturb my.
না না
Application item number 3.
But here, my lord, I have concluded my submission.
yes
So far as the same payment of the retired employees of the my landed senior friend will reply.
Yes, proceed.
My lord, the claim
You
of,
are appearing on behalf of?
I am appearing on behalf of the uh, respondent numbers 4, 5, and 6.
Respondent number 45.
4, 5.
You have filed the opposition.
Yes. This is my lord, Indian Institute of Management Capital.
Yes.
My lord, the claim of the petition for revision of pay is based on a government letter dated, my lord, 28th of February 1989. That is at annexure P1, page 23 of the petition. It's a Government of India letter providing for revision of the pay scales of certain categories of employees. My lord, whether the petitioners, my lord, who are working as librarians, library staff in the Indian Institute of Management, Calcutta, they claim that they are covered by this, therefore they are entitled to hire. They moved this honorable court. First, my lord, the matter was decided by Justice Ajit Kumar Sengupta, my lord, in 1994, when his lordship was pleased to direct and pleased to hold that they are entitled to pay division. In the division bench, in 1998, division bench said that since the matter relates to determination of certain facts also, we direct the authorities to consider this aspect, taking into account the relevant facts. Now that direction was given for consideration. That is in 1998.
Yes.
My lord, thereafter, an order was passed by the authorities. My lord, not giving this benefit. That was again challenged.
12th of January 1999.
Exactly. Now, my lord, after that, that order was challenged by them, and one of the learned single judges of this honorable Justice Bhaskar Bhattacharya held in their favor. In appeal, the appeal against that order failed. My lord, this is the position.
Yes.
And the ultimately matter went to Supreme Court, and on 9th of December 2020, the Supreme Court did not interfere. Therefore, the position remains that this particular government letter of February 1989, under that, the rights of the persons who had filed these proceedings was decided in their favor. The question now that crops up here is whether, my lord, these persons, the petitioners who are filing this petition in 2022.
Yes.
2022, they
that
are
the petitioners before this court.
Before your lordships. They filed this petition in 2022.
Okay.
Claiming, my lord, identical benefits. The question that your lordship needs to consider is whether the same benefit is to be extended to them or not.
Whether they are similarly circumstances person or not.
No, that's not the only thing. Not similarly circumstance maybe, but the question is, are they entitled?
Okay.
To get this benefit?
Okay.
Because, my lord, the Supreme Court has.
You are stressed further. Yes.
Yes, because why this? Because there are several judgments I shall point out to you.
Okay. Okay.
Judgments which say that once right is determined, it can be in rem or in persona. If it is in rem, it applies to all.
Yes.
Even those who are not parties before them. If it is in personam, the judgment is restricted to the parties before them.
Yes.
This is one aspect. The other aspect is the question of waiver, delay, and acquiescence. in 1989 right is being sought to be enforced in 2022 after 33 years. And there are, my lord, 9 persons, right? There are 9 petitioners. Hold on. I'm sorry. There are 9 petitioners, of whom 7 had retired and 2 are dead.
Okay.
All retired, 2 of them dead. And they filed this proceeding after their retirement and after death. This is the position. Now, the first question that comes up is the judgment, previous judgment,
Judgment of division bench.
Yes. A single bench, followed by division bench, and up to the Supreme Court, whether those were in rem or in person.
Yes.
Beloved, if your lordship kindly comes to the judgment of Justice Bhattacharjee, Justice Bhaskar Bhattacharjee, at page 132. It starts at page 132. Then, my lord, and after dealing with all the facts, the conclusion that his lordship is drawing, that your lordship will find from page 150. Kindly, my lord, come to page 150.
Yes.
150. My lord, I am from the continuing paragraph. Only, my lord, 6 lines from the bottom of the continuing paragraph. Since there is no special reason, as your lordship kindly got it, 6 lines from the bottom of the continuing paragraph. Kindly come to the judgment, my lord. 6 lines from the bottom of the continuing paragraph. Since there is no special reason, as your lordship got it, for not giving the scale of library staff of university to the petitioners. Kindly note this. To the petitioners. There is also no reason for not giving such scale retrospectively from 1986, date from which similarly placed staff doing equal work have been given such benefit.
Yes.
Then next paragraph. I thus set aside the orders impugned and direct the respondent authority to convert the scales of pay given to the library staff of the petitioners to the library staff of the universities, not below the IIM, to the petitioners. Therefore, this is the entire judgment.
Yes.
The same benefit as given to university librarians, library staff, are to be given to the petitioners before the court. And when it goes up to the appeal, Lord, there is
So
no
your
additional-
submission is the petitioners mentioned in the judgment speaks only to the petitioners.
Exactly. Petitioners means petitioners. Those who had
not their status.
Not the status, not the state, not the librarians as such. Given to the petitioners.
That means it's the judgment in personam.
Judgment in person. Lord, this goes up in appeal. The appellate order is at page 154.
Page 154.
Lord. Finally come to page 161, the concluding part.
Yes.
The appeal fails and is hereby dismissed. And the Supreme Court order, that is at page 163. The civil appeal is dismissed. 162 and 160.
Yes.
Civil appeal is dismissed. Therefore, Lord, this is a judgment in personam. The first point is this is a judgment in person.
Yes.
The second aspect is the delay, there is a delay of 11 plus 22, 33 years in approaching the court. And in my affidavit, the records of the proceeding will show that they stood retired before the writ petition was filed, and two of them, numbers 8 and 9, they were not the employees, but the representatives, I mean, they are subject. Therefore, this is their status. After retirement and after death, they suddenly rise up from the slumber and seek to enforce a right which existed. They never felt aggrieved by the pay they were offered. They had all along accepted this. They waited for the others who had moved the court. What result comes out from those proceedings? If the result goes in their favor, then we will take steps to assert our right. Now, this means, my lord, as in the case of limitation, delay, latches, all these principles, the right doesn't evaporate. The remedy goes. And I'll cite certain judgments of the Supreme Court where the Supreme Court said that when employees remain silent about their rights, do not assert their rights through proceedings in court, it has to be taken that they have waived their right and they have acquiesced in the situation in which they are today. Therefore, on the ground of this laches and delay, the courts have dismissed their claim. The other line of judgment is that if you wait for others to fetch a good result from the court and then move your petition before the court, your position is that of a fence sitter. You are looking for what the result of the game is. You are sitting on the fence, looking at the game, how the game is going on. If the game goes in favor of a particular way, goes in a particular direction, then we'll decide when I will move. Supreme Court says that in respect of such persons, court will not extend its discretion to confer benefit upon. There are a number of decisions on this. I will not burden the court with so many judgments. I shall point out only 2 or 3 judgments. Now, 2011, I'll first cite 2011, volume 4. Online. 2011, volume 4, Supreme Court SS 374. 374.
Yes.
Just
BSNL.
Yes, Bharat Sanchan Nigam Limited. Page 374, paragraph 26 to 32. I shall place 26 to 32. Now then from 25. From 25. The principle laid down in K.I. Shepherd that it is not necessary for every person to approach the court for relief, and it is the duty of the authority to extend the benefit of a concluded decision in all similar cases without driving every affected person to court to seek relief would apply only in the following circumstances. A, where the order is made in a petition filed in a representative capacity on behalf of all similarly situated employees. B, where the relief granted by the court is a declaratory relief which is intended to apply to all employees in a particular category, irrespective of whether they are parties to the litigation or not. C, where an order or rule of general application to employees is quashed without any condition of reservation that the relief is restricted to the petitioner before the court. And D, where the court expressly directs that the relief granted should be extended to those who have not approached the court. On the other hand, where only the affected parties approach the court and relief is given to those parties, the fence sitters who did not approach the court cannot claim that such relief should have been extended to them, thereby upsetting or interfering with the rights which had accrued to others. 27. In Jagadish Lal versus State of Haryana, etc., the appellants were general candidates belatedly challenged the promotion of scheduled caste and scheduled tribe candidates on the basis of decisions in such and such. And this court refused to grant the relief, saying this court has repeatedly held the delay disentitles the party to the discretionary relief under Article 226 or 32. It is not necessary to reiterate all the catena precedents in this behalf. Suffice it to state that the appellants keep sleeping over their rights for long and elected to wake up when they had the impetus from Birpal Chauhan and Ajit Singh ratios. But Birpal Chauhan and Sabharwal cases kept at rest the promotion already made by that date and declared them as valid. They were limited to the question of future promotions given by applying the rule of reservation to all the persons prior to the date of judgment in Sabharwal, which required to be examined in the light of the law in Sabharwal. Thus, earlier promotions cannot be reopened. Only those cases arising after that date would be examined in the light of the law laid down in Sabharwal and Birpal Chand Singh's equally. Ajit Singh's case, if the candidates has already been further promoted to the higher echelons of service, his seniority is not open to be reviewed. In ABS Karmachari Sangh case, a bench of 2 judges to which 2 of us, namely Ramaswamy and G.V. Patnaik, were members, had reiterated the above view, and it was also held that all prior promotions are not open to judicial review. In Chandarpal, etc., a bench of 2 judges consisting of such and such considered the effect of Birpal, Sabharwal, and Karmachari, ABS Karmachari Sangha cases and held that seniority of those responses are not troubling yours. You know, kindly come to 28. Since the respondents preferred to sleep over their rights and approached the Central Administrative Tribunal only in 1997, they cannot get the benefit of the order dated 7/7/1992 of the tribunal in Santosh Kapoor case and will only be entitled to the benefit of the circular dated 95, which was in force in 97. We also find on a reading of paragraph 8 of the order dated 7/7/1992, 7/7/1992 of the Central Administrative Tribunal in Santosh Kapoor case, where the tribunal gave liberty to the government to consider employees who are senior to the applicants in that case, in the scale of such and such, and who may have already been given the scale of this at the cost of those who are senior in the basic grade by any different interpretation of the BCR scheme than one given by the tribunal by suitable adjustments in the number of posts of obligation. It appears that pursuant to the liberty granted to the government, Lakpat Rai Gumbar had been promoted to grade 4 scale with effect from 8/1/1993 because of his seniority in grade 3 scale over the 2 respondents in civil appellate such and such, even though he was junior. Hence, Lakpat Rai Gumbar was promoted to one of the posts in grade 4 created by the government for the specific purpose of protecting promotions done on a different interpretation of the BCR scheme by the government as allowed by the tribunal in the order dated 7/7/92 in Santosh Kapoor case. And the respondents in these appeals can have no claim of promotion to these supernumerary posts. Moreover, if the respondents were in any way aggrieved by the promotion of Lakpat Rai Gumbar and others who are junior to them in the basic grade, they could have challenged their promotion in the appropriate forum, but they have not done so. We further find on a reading of the circular dated 95 of the government that after the order dated 92 of the tribunal in Santosh Kapoor case was affirmed by the court in such and such, the government undertook a review of the existing procedure of promotion and grade for this. Now, kindly come to 32. The Central Administrative Tribunal was therefore not right in allowing wage number such and such by the order dated 2000, directed the government to consider promoting the applicants to grade 4 with effect from the dates that immediate juniors in the basic seniority were so promoted, subject to their being found fit consequential benefits of seniority as well as arrears and retirement benefits in the case of those applicants who are retired on superannuation. Where, in our considered opinion, the High Court ought to have interfered with the decision of the tribunal. Therefore, even those retired, my lord, their cases were required to be considered by the tribunal. And High Court affirmed that. Supreme Court said, no, we don't take it. May I place this part once more? In fact, 32. The Central Administrative Tribunal was therefore not right in allowing original applications number such and such by the order dated 11/8/2000, directing the government to consider promoting the applicants to grade 4 with effect from the dates that immediate juniors in the basic grade seniority were so promoted, subject to their being found fit with consequential benefits of seniority as well as arrears of pay and allowances and of retirement benefits in the case of those applicants in the ways who had retired on superannuation. In our considered opinion, High Court ought to have interfered with the decision of the tribunal. Therefore, tribunal was not right. Now, my lord, the other judgment is 2014, volume 4.
Yes, no, today I have one special bench with Justice Mukherjee at 3. Okay, so I have to left after 15 minutes. 10 to 15 minutes. 10 to 15 minutes I'll carry on.
Here are 2014 volume 4 Supreme Court cases, page 108.
No, if you have some engagement, you can proceed, go.
Simply go.
No, you can proceed, go. Okay.
I'll come back before
Yes. Yes.
Here are paragraphs 16 and 17.
Paragraph
16 and 17.
Yes.
Thus, the doctrine of delay and laches should not be lightly brushed aside. A read court is required to weigh the explanation offered and the acceptability of the same. The court should bear in mind that it is exercising an extraordinary and equitable jurisdiction. As a constitutional court, it has a duty to protect the rights of the citizens, but simultaneously, it is to keep itself alive to the primary principle that when an aggrieved person, without adequate reason, approaches the court at his own leisure or pleasure, the court would be under legal obligation to scrutinize whether the lease at a belated stage should be entertained or not. Be it noted, delay comes on the way of equity. In certain circumstances, delay and laches may not be fatal, but in most circumstances, inordinate delay would only invite disaster for the litigant who knocks at the door of the court. Delay reflects inactivity and inaction on the part of a litigant. A litigant who has forgotten the basic norms, namely, procrastination is the greatest thief of time. And second, law does not permit one to sleep and rise like a phoenix. Delay does bring in hazard and causes injury to the lease. In the case at hand, though there has been 4 years delay in approaching the court, yet the read court chose not to address the same. It is the duty of the court to scrutinize whether such enormous delay is to be ignored without any justification. That apart, in the present case, such belated approach gains more significance as the respondent employee being absolutely careless to his duty and nurturing a lackadaisical attitude to the responsibility had remained unauthorizedly absent on the petition from kind of all illness. We repeat at the cost of repetition that remaining innocuously oblivious to such delay does not foster the cause of justice. On the contrary, it brings in injustice, for it is likely to affect others. Now, in our case, it will affect the institution. Because, if we have to pay higher pay from 1986 at a higher scale of pay from time to time to all these employees, this will cause serious prejudice to us. Financial liability.
Yes.
Such delay may have impact on others' ripened rights and may unnecessarily drag others into litigation, which in acceptable realm of probability may have been treated to have attained finality. A court is not expected to give indulgence to such indolent persons who compete with Kumbhakarna or, for that matter, Rip Van Winkle In our considered opinion, such delay does not deserve any indulgence, and on the said ground alone, the writ court should have thrown the petition overboard at the very threshold. But the position is this. Here, the court was considering a delay of 4 years. Now, before your lordship, the list presents a situation where the delay is of 33 years. In 1989, the government of India issued this memorandum. I mean, this letter conferring certain rights regarding revision of PIC.
Yes.
In 1989, my lord, is a batch of petitioners. They immediately approached the court, and my lord, through repeated litigations, they attained their right. They are successful in getting their right, which got ripened. Now, that was the situation, and the matter was pending. In 2008, the judgment of the division bench was already passed. Single judge judgment 2004, just first court. 2008, the division bench, all my lord in favor of the petitioners there. Now, Supreme Court, my lord, the SLP took a long time, of course, 12 years. In 2020, that appeal was dismissed, civil appeal was dismissed. But they had been sleeping all throughout. My lord, they approached the court. Your lordship will find in the petition they plead that they are all retired persons. My lord, if your lordship takes the petition, if your lordship kindly takes the trouble of looking at the affidavit page at page 22 of the petition.
Page 21.
Page 22. 22 is the affidavit page. I show it to your lordship just for the purpose of showing that the person who affirmed this affidavit is 70 years. Therefore, after 10 years of return, he is filing this. And there is not any attempt to justify why this delay had taken place. Unexplained delay in respect of all the petitions. If your lordship comes to paragraph 1 of the writ petition, paragraph 1 of the writ petition at page 4.
Yes.
Your petitioners are senior citizens and living permanently, etc. Your petitioner number 1 to 7 are retired librarian, deputy librarian, senior assistant librarian, contingent tobacco. And petitioner number 8 and 9 are legal heirs of since deceased seniorist. And from the petition, Lord will not find Lord any explanation for this. Why they were sitting there. Lord, 2021, volume 13. I cite another judgment on this. And this is the last one I will cite. 2021, volume 13. Supreme Court cases, page 225. UP Power Corporation versus Ram Gopal. 225. Miller, kindly straightway come to paragraph 11. At page 230.
Yes.
Paragraph 11. Whilst it is true that limitation does not strictly apply to proceedings under Article 32 or 226 of the Constitution, Nevertheless, such rights cannot be enforced after an unreasonable lapse of time. Consideration of unexplained delays and inordinate lapses would always be relevant in writ actions, and the writ courts naturally ought to be reluctant in exercising their discretionary jurisdiction to protect those who have stepped over wrongs and allowed illegalities to foster. Therefore, my lord, the remedy may be there, the legal right may exist, but the remedy is lost. As my lord applies to every principle of limitation. Fence sitters cannot be allowed to barge into courts and try for their rights at their convenience, and vigilant citizens ought not to be treated alike with mere opportunists. On multiple occasions, it has been restated that there are implicit limitations of time within which the writ remedies can be enforced. In S.S. Balu versus State of Kerala, this court observed thus: it is also a well-settled principle of law that delay defeats equity. It is now a trite law that where the petitioner approaches the High Court after a long delay, relief spread for may be denied to them on the ground of delay and laches, irrespective of the fact that they are similarly situated to other candidates who obtain the benefit of the judgment. Kindly consider, my lord, in the context of our facts. There is a group who had fought for their rights and they were successful. Do the present writ petitioners have enjoy any right, my lord, to seek similar relief? The court says no. Relief spread for may be denied to them on the ground of delay and laches, irrespective of the fact that they are similarly situated to the other candidates who obtain the benefit of the judgment.
Yes.
That is the first batch of petitioners. In paragraph 12. Similarly, in Vijay Kumar Kaul versus Union of India, this court, while considering the claim of candidates who, despite being higher in merit, exercised their right to parity much after those who were, though lower in merit, but were diligently agitating their rights, this court observed. Therefore, juniors were vigilant, conscious of their rights. They fought out. Seniors were sleeping. Seniors later on came. Court said no. Kindly, I read out the quoted paragraph 27. It becomes an obligation to take into consideration the balance of justice or injustice in entertaining the petition or declining it on the ground of delay and laches. It is a matter of great significance that at one point of time, equity that existed in favor of one melts into total insignificance and paves the path of extinction with the passage of time. Equity existed in their favor if they had come in time. Then it starts melting and ultimately evaporates, fades into extinction. Then paragraph 13. We may hasten to add that these principles may not, however, apply to judgments which are delivered in rem. The state and its instrumentalities are expected to, in such category of cases, to themselves, extend the benefit of a judicial pronouncement to all similarly placed employees without forcing each person to individually knock the doors of court. This distinction between operation of delay and laches to judgments delivered in rem and in personam is lucidly explained, is lucidly captured instead of EP first Arvind Kumar Srivastava, laying down that 22.1 normal rule is that when a particular set of employees is given relief by the court, all other identically situated persons need to be treated alike by extending that benefit. This is the normal rule. Not doing so would amount to discrimination and would be violative of Article 14 of the Constitution of India. This principle needs to be applied in service matters more emphatically, as the service jurisprudence involved in this court from time to time postulates that all similarly situated persons should be treated similarly. Therefore, the normal rule would be that merely because other similarly situated persons did not approach the court earlier, they are not to be treated differently. Paragraph 22.2. However, this principle is subject to well-recognized exceptions in the form of laches and delays, as well as acquiescence. Those persons who did not challenge the wrongful action in their cases and acquiesced into the same and woke up after long delay only because of the reason that their counterparts who had approached the court earlier in time succeeded in their efforts, then such employees cannot claim that the benefit of the judgment rendered in the case of similarly situated persons be extended to them. They would be treated as fence-sitters, and latches and delays under the acquiescence would be valid ground to dismiss the claim. Then 22.3. However, this exception may not apply in those cases where the judgment pronounced by the court was judgment in re. With intention to give benefit to all similarly situated persons, whether they approach the court or not. With such a pronouncement, the obligation is cast upon the authorities to itself extend the benefit thereof to all similarly situated persons. Such a situation can occur when the subject matter of the decision touches upon the policy matters like scheme of regulation and the like. On the other hand, if the judgment of the court was in personam, holding that benefit of the said judgment shall accrue to the parties before the court, and such an intention is stated expressly in the judgment, or it can be impliedly found out from the tenor and language of the judgment, those who want to get the benefit of the said judgment extended to them shall have to satisfy that their petition does not suffer from either latches or delays or acquiescence. Therefore, an explanation is called for. Not, my lord. Oh, sir.
Today.
Yes, we are not today.
Yes. So when can we?
Lord, Monday will it be convenient for you?
No, Monday possible. Next Friday?
I can privately request my learned senior friend to give the citation so that I can make myself ready on the last of only 3. Yes.
No,
I'll get it and make myself ready.
Yes.
So that on that day, Mr. Gupta will be concluding, I can.
Right.
Yes. Reply.
I'll definitely stuff like that today, right now.
1st of March at 2 p.m.
First of March, you lot the original side matters, no?
Oh, fine.
Original side is only 5 to 2 minutes. 2
and
to
that
5
also
minutes.
should be matters. Nobody.
Yes. Nobody appearing. The first matter will come there. No issue.
Nothing.
1st March.
Very well. Next Friday.
Lots.
Next Friday. Okay.
Hmm.